Hi, everybody. Thanks for joining us. Welcome to the ETF BILD Project, ETF and Fund Regulation, the last 3 months of 2024. Part 1. My name is Bibb Strench. I'll be the moderator today. And let me just briefly describe ETF BILD if you're not familiar with it. Myself, John Jacobs, Rich Curie, Justin Mice, started ETF BILD Project primarily just to be a forum for issues that affect ETF professionals. And we've always focused more on the smaller and ETF fund complexes and participants in the industry. So, as we all know, November 5th, there's an election. Hopefully a president will be elected on that date. And, you know, everybody has probably been inundated with via social media, whether it's text on your phone, news stories about the election and the candidates. But I think what most people don't realize are there are a lot of other activities going on right now that will especially impact the ETF industry and professionals who are in it, which is why we're focusing on these 4 months. And I'll talk about that in a second. And that activity is occurring in large part in the city where the 3 of us are in Washington, D.C. So we have 2 panelists that know Washington, D.C. really well. They know the SEC over by Union Station, the Hill, as well as the ICI, where the 2 panelists are sitting are blocks away from the White House. So what I thought I would do is let Jane Heinrichs and Lisa Hammond introduce themselves.
Well, thank you, Bibb, and thank you, ETF BILD Project, for inviting me. I'm Jane Heinrichs, and I am head of U.S. Regulatory Affairs for Federated Hermes. I worked with Lisa for 18 years at ICI, so this seems like home. I have over 20 years of public policy experience here in DC, and a lot of my experience has been around money market funds and ETFs. So those are pretty much my primary areas, but now I kind of cover everything. So
great. And I am Lisa Hammond. I want to echo Jane's thanks. We are happy to be here with you today. I am the Associate Managing Director of the Independent Directors Council, which is the part of ICI that focuses on fund directors and fund governance. So Jane and I are both attorneys, and we have the same kind of policy background, but my focus is on fund governance.
Thanks, both of you. And I'm an attorney as well, I'll admit it, since Lisa and Jane did. I am in DC at the law firm Thompson, Hine, and I focus primarily on ETFs, but other types of registered investment companies. I will be the moderator today, so kind of the format is I will ask questions really concerning, you know, what may happen with the outcome of the election. And you may wonder, you know, why are we talking about it now? And the reason is, like I alluded to, there are a lot of things actually kind of in the works. I think both presidential candidates have transition teams. We know in the past, even at this early stage, the transition teams are focusing on a variety of issues and staffing up, and including the SEC. And in this industry, every 4 years becomes more and more important as it keeps adding trillions of dollars. So there are people right now working, thinking about the transition, even if their candidate doesn't win. there's the chairman and the commissioners themselves. They're thinking about their future. We'll talk about that, as well as the SEC. Like, what does the SEC do right now? They have a rulemaking agenda. Are they strategizing, trying to get rules adopted, or are they going to wait? So it's an interesting period where people might not be aware, but there are a lot of things going on. And then, after the election, that will pick up, which is why, we have a part 2 that will occur, and we'll talk about with probably a little more clarity of what may be coming for down the road for the ETF industry. So we're going to focus, today kind of on it's almost like the 3 branches of government. We're going to talk about the SEC, which is an independent administrative agency and the most important agency, obviously, for ETFs. Where you'll see that we talk about Congress, both sides, the House and the Senate, as well as the judiciary, which is kind of interesting because lots of things are happening in the courts that were started back in the Trump administration. So with that introduction, let's get into the discussions. And Lisa, I'll start with you. So like I said, everybody's anticipating November 5th for a variety of reasons. What are some of the possible outcomes of the election? Really, like I said, at the presidential, congressional, and agency levels.
Sure. So I guess let's start at the presidential level. It's somewhat of a toss-up. Polls are pretty much predicting 50-50. You could go either way to the extent that you even trust polls. It might depend on voter turnout. It might depend on, how many people vote early. It might depend on the weather that day, but it's kind of a 50-50 toss-up. So let's, I guess, go down both paths. Most people are predicting that the House will go with whoever wins the election. So if Harris wins the election, Democrats will control the House. If Trump wins the election, Republicans will control the House. The more interesting thing is the Senate. I think most people are predicting that will go Republican. I think Democrats only have, Republicans only have a couple of seats that they need to win, whereas Democrats are defending a lot of seats. So I guess let's take it both ways, but assuming the Senate goes Republican, which is pretty significant, because let's say Trump wins, they'll have the full trifecta, right? Republicans likely will control the House and the Senate. And so Trump has said that tax reform will be his #1 priority. The Tax Cuts and Jobs Act will be extended because key provisions of that are expiring at the end of 2025. So we're going to see some movement in the tax area. I think it might be messy, but it will be a lot easier to do that if Trump wins. In terms of who will take over the SEC, Trump is notoriously unpredictable. I don't think he's spending a lot of time thinking about cabinet heads, agency heads right now. I think he's a little bit all over the place. Like I said, he's unpredictable, but I think it's fair to say that we could see somebody more of the ilk of like a Jay Clayton, which we saw before. There was just an article yesterday naming Dan Gallagher, who was an SEC commissioner and now is the head of Robinhood. We've heard other names, maybe Hester Peirce, who's currently an SEC commissioner, who's been known as the moniker Crypto Mom, and we're going to talk about crypto later on in this webinar. So it's really too early to predict exactly who will be the head of the SEC, but we will see major shifts in policy heads if Trump wins. If Harris wins, it will likely be a different story, of course, But assuming that we still have a Republican-led Senate, it's going to be difficult for her to get a nominee through. The head of the SEC, the chair, needs to be confirmed by the Senate. And so that's going to be a tough sell to have somebody, if somebody who otherwise would have an easy time if the Senate were controlled by Democrats. It might just be as easy for Harris to keep Gensler in place rather than to put through a new nominee. So that would be an interesting thing. I think it's typical after an election for the chair to submit a resignation, and then whether that resignation is accepted or not is another story. And Gensler has, come out and said, I'm not going anywhere. His term goes through 2026. So I think that kind of remains to be seen. But let's say Gensler leaves, Harris wins, and the Republicans still control the Senate. I think we'll see a more moderate person being put through or nominated, not really of an Elizabeth Warren type, maybe a big bank CEO or somebody who is going to toe the line a little bit more easily, and they won't have to worry so much about the confirmation process. But on the tax side, I think there's still going to be an incentive to extend those tax credits. So, they might raise corporate rates to make up for the individual rates. And then, for this community, it will be especially interesting because they might be going after money from ETFs or from the retirement system or something like that. So I think that we are going to see action either way, I guess. Would you agree?
Yeah, no, I totally agree. I think next year is expected to be a huge year, regardless of who wins in the tax area. So I think we will see legislation that comes back looking like the Wyden bill from years ago that will go after the ETFs. So I agree.
Great. Yeah, I mean, it is fascinating because there's a matrix of outcomes here. But let's drill a little bit more into the tax area, especially how it impacts ETFs. As the ETF ascendancy has been amazing. I witnessed it when the first application came in at the SEC when I was there. All the way now, it's still a rocket ship. And what's propelling that? Obviously, it's a great product because you can trade during the day, but also it has inherent tax advantages over other products, and those tax advantages are grounded into statute, not rulemaking. So to actually change those, modify those, would take an act of Congress. Lisa, is that going to be a possible bill, a topic of discussion, a possible way to get revenue, to look at maybe amending that provision and either weakening or eliminating the great tax advantage ETFs enjoy?
I mean, I think with the state of the country the way it is, there's going to be pressure to look for money somewhere.
Under every
And under every rock, in the couch cushions, however you want to say it, like ETFs I think are an easy target. So I think you might see some differences around the edges, but we got a question about whether it will happen regardless of who wins. I think it's a question of process, right? It will be easier if there's, depending on who wins, right? Trump, I think, is seen as more business friendly and will be less likely to be incentivized by that. But Harris is going to be looking for the money more. So,
yeah, I tend to think that it probably won't make any difference if tax is a huge issue next year and there's a pressure to keep taxes on the lower side, they're going to be looking for revenue. And I think that it's inevitable. I think that the ETFs will come up in the discussions. And I know the industry will we'll, get together again, and a lot of it is just education. And we'll restart the education process up on the Hill to explain the benefits that this provides to ETFs as well as retail investors. So it'll be a really important push for the industry. We did it last time, and we'll do it again. So
yeah, I mean, I think it's harder to predict the outcome, but I agree with Jane. Certainly, it will be a topic for conversation, and it will keep a lot of us busy.
And I say the thing, I'm not with the ICI anymore, but I was back then, and I know it was a big priority, and I could probably predict they will push back.
Absolutely.
So, yeah.
Okay, so let's move on to the SEC chair. As Lisa said, Chairman Gensler may not be going anywhere. That would be surprising to me, or something that's not typically has been done in the past. So let's assume there may be a new chair. And it's always interesting, we went from Mary Jo White recently to Jay Clayton, and then to Chairman Gensler. And a lot of things, stay the same, but a lot of things change. I think with Chairman Gensler, he got a couple of mandates from the Biden administration. I think consumer protection, ESG were big things that they encouraged that he would take action on at the SEC. And then he had his own pet projects, which is capital markets. And boy, did they bear fruit. Did they happen? Yes, over the next 4 years. I mean, we've all been dealing with the names rule, which is to me very consumer oriented, the TSR. And then there's been a lot of rules passed, and maybe more to come, impacting the capital markets where ETF shares trade. So, Jane, with that long windup, will it be business as usual at the SEC, or do you think? And this is again assuming maybe a new chairman, or do you think things may change?
Well, before I answer your question, I thought I would just give a little stats just to kind of get everybody on the same sort of level set as to why Gensler is a little bit different. So I would say that we've just come through a period of very aggressive rulemaking. And just to put it in perspective, Gensler, who's been in office since 2021 and will continue until 2026 in theory, if he were to go his full term. Up until now, he's had over 50 rules he's proposed and or adopted. And if you compare that to Clayton and White for their full terms, Clayton had 45 and White had 22. But it really, the numbers aren't actually as interesting as the subject matters are more complex under Gensler. The breadth, the complexity just generally of the rules, the overlapping nature of the rules, as well as the number of alternatives that are offered in the rules. So what has happened over the last couple of years, when they put out a proposal, they propose something, and then there's 10 pages of alternatives with variations. And so it makes it very difficult, and it has made very challenging for the industry to comment, especially when there are overlapping proposals at the very same time. So it's been a challenging period for the industry to respond to these proposals. The average comment period also has gone down under Gensler. It's only about 46 days, which is about 28% fewer days given to comment for the public comment than it was under previous chairs. Getting back to the Reg Flex, which is the Regulatory Flexibility Act, is basically, it's a provision that the SEC, it'll kind of lays out what the SEC's plan is for the short term and the long term. And it's really important to remember that the chair is the one who drives the agenda. And that's why it's so important to know who's in charge here. And the Regulatory Flexibility Agenda has indicated that there's what's coming up is some re-proposals. Again, as part of those 50 proposals and final rules that came through, there was a few that garnered a lot of negative feedback. And the SEC, I think, took that in and they are re-proposing. And we're expected to see re-proposals for the predictive data analytics, which if folks remember, that was in response to the GameStop frenzy. There was the swing pricing, hard close, open-end fund liquidity rule at proposal, and that was in response to the March 2020 market volatility. There was also a safeguarding custody rule that would expand custody further than it's ever been, and that's a rule making that's predicated on Dodd-Frank. All of these proposals were criticized, and in fact, there was a lot of opposition, bipartisan even from Congress. So we actually saw a lot of letters put in by both sides, for instance, on the swing pricing, because there was concerns about swing pricing and its impact on retirement. And I think, Lisa, there was a lot of
board comments for sure.
Yeah.
I mean, it's funny when you ask, is it going to be business as usual? Because as Jane points out, it has not been business as usual.
Yeah.
I think it's been so unusual that I think we can expect it to go back to business as usual and be less chaotic and less just crushing in terms of, Jane had really interesting statistics about the numbers of things, but the proposals that have been put out have had such broad potential consequences. They've really been game changers if they had all passed. And I think with the pushback bipartisan from the Hill and from the industry, from directors, from folks like ICI and others, I think that the pendulum has got to swing, right? We can't keep up this pace. And I don't think there's any appetite for it from anyone. So,
and as we'll be discussing in a few minutes, the judicial, there's also a whole line of court cases that have also, I think, stymied some of what Gensler's been doing as well. And so I think regardless of sort of who wins the election, I do think that it's going to change the outcome of what we see for the SEC next year. So sort of a long-winded answer to your probably more basic question.
Well, we have these interesting periods coming up. So we have until November 5th, the election. Then we have a transition period because the new president won't take office until January 20th. You mentioned a lot of these rules. Any speculation? Is the SEC, I've heard the expression, are they going to try to empty their rule making tank either up until November 5th or January 20th? Or do you see the rulemaking process chugging along under its usual kind of time frame?
I actually would be really surprised if we see much, if anything, happening between now and January. I think we might see if there was something that was not, that could get a 5-0 vote, maybe you might see something, but a lot of these that we've been talking about are partisan split. And I just don't see them putting out any re-proposals even adopting anything between now and
stop chugging.
I think it stopped. I do. I think this is truly, we're sort of in a lame duck.
Right.
And I think they will just kind of wait and wait and see what happens.
Yeah, it's interesting because I think, typically you think of the election as a shift. I think we've already seen the shift, right? We've already seen a slowing down. We've already seen proposals that otherwise might have been pushed through to now saying, oh, they'll be reproposed and maybe not even until April, which, I just don't think they're going to see the light of day. I think, the Congressional Review Act is playing a role where things are going to be subject to scrutiny, but things have already been scrutinized by all the litigation, which I know we're going to talk about. But, we might not see a new chair until the springtime. And I just don't think, unless, like Jane said, it's non-controversial and it can pass with a 5-0 vote, or if it's some egregious, enforcement matter like a Ponzi scheme or something, I don't think that we're going to see much out of this commission.
I think that's right. And as far as, how fast things happen afterwards, I mean, So I was just talking about the regulatory flexibility agenda. Again, that's what, that is Gensler's, what he wants to do. All bets are off if he's not in the chair, if he's not still the chair in, next year. If Trump wins, I think Gensler's out probably immediately. And then I think you're a complete shift of priorities. If Harris wins, as she said, Gensler may stay on, but it doesn't necessarily mean that that they're going to stay with the same priorities. It really depends. So I do think that it's going to be difficult to continue what he's been doing in terms of finishing sort of his rulemaking at this point.
An interesting circumstance that's happened in the past is when a commissioner or the chairman has resigned and you end up with 2 Republicans and 2 Democrats. What happens then? How does that impact rulemaking and really the functioning of the SEC?
I think it's the same thing, but not much will happen. I mean, things are so partisan these days, you really need a majority to get much done. So unless it is a
Non-controversial issue.
right.
Yeah, so much of this, so many of the proposals that have come out over the last couple of years have been 3-2. The adoptions have been 3-2. If we're down to 2-2, you're not going to see a whole lot, at least until they put in, fill that 5th seat. So again, that just because the numbers don't work out that way, which does impact rulemaking, right? Because it just slows everything down. But I doubt that'll happen. They'll put someone in place. I don't think they're going to want to just, stop everything. So,
Well, but that someone has to get confirmed.
yeah, and that's it. Well, that's right. Yeah.
Right.
Yeah, and that's such a big difference than when I was at the SEC, because when I was at the SEC, almost every rule was 5-0. And
Right.
that doesn't mean it wasn't easy. That was back at 455th Street. But everybody on the 5th floor, they walked around until they got every commissioner to get in line, and it ended up with some compromises, which was maybe ended up with better rulemaking. Who knows? So, one of the things I believe, and I don't know if you agree or not, but again, comparing it to the old SEC, I think there's a much more consumer-oriented approach, at least in the Division of Investment Management, and I think that's coming down from the chair. And I gave a couple of examples. In assuming you agree somewhat, do you see that kind of angle with like the types of rules that are proposed, the types of disclosure that's insisted upon by the staff? Do you see that kind of consumer gloss continuing at the SEC and not the traditional, the buyer beware, as long as you sue on the prospectus, and that's all the consumer really had as a way to feel protected?
I would say no. I mean, I think there's been so much pushback by the industry, by the courts, by politicians. I don't see how that could be sustained. They have a pretty high profile consumer advocate in the chair's office now. And once Gensler leaves, I would assume she would leave as well. And so I think we're going to go back to what I would call normalcy, which doesn't mean things won't be bipartisan, but they won't be so extremely consumer protection oriented, I think. I don't know. What do you think?
Yeah, I tend to agree. I think, although I do think that the trend is going in that direction more, away from just disclosure beware and more towards more transparency. Investors are looking for more information about ESG. They're looking for more things. So I do think that there are other pressures, whether it's standard setters or others that are pushing beyond, but it's hard to know. I mean,
but yeah, I mean, the 40 Act has always been disclosure.
Right.
So I think transparency is first and foremost
Yep.
what we're about. The consumer protection just feels like it's code for we'll tell you what you want and what's good for you.
Right, right.
So I think we'll get away from that a little bit. I agree that the trend has been away from just a buyer beware, but I do think that it won't be so so much telling people what's good for them.
And we heard that from, the House Financial Services Committee recently had a hearing where they invited the entire SEC, all the commissioners. And certainly we heard that from the Republicans, Commissioner Peirce and Ueda, that, there has been too much sort of protecting, and you really need to let the market be innovative. You need to let things happen. I mean, you see this over and over. So certainly I think if there's a Republican-led SEC, you're going to see more willingness to have innovation and not be so sort of afraid of protective, that type of thing. So yeah, it's hard to know. I mean, again, this all comes down to the election.
Couple more points on the SEC, and then we'll move to the judiciary. Crypto. So ETFs, mutual funds, other types of investment companies registered are not allowed to invest in cryptocurrencies. And when I say not allowed, there's no Investment Company Act 1940 statutory prohibition or rule prohibition. It really comes down from the chairman's office. Now, everybody knows Chairman Gensler's view of crypto. With that said, the investment management sister division, Corporation Finance, they've begrudgingly but slowly loosened things up. And now there are a multitude of ways for ETFs and mutual funds to get indirect exposure to crypto. And I will say, crypto, Bitcoin, it's a very volatile asset. So that there is some, I understand Chairman Gensler's position on crypto. But with these new spot Bitcoin trusts in a net nature, now ETFs and mutual funds can gain exposure to crypto. Obviously, Trump has come out. He attended, I think, a conference in Nashville or something. He's very pro-crypto. Even if Trump is not elected, any kind of predictions on what will happen to crypto and whether things will loosen up a bit and give more flexibility for mutual funds and ETFs to have exposure to crypto?
Sure. So it's interesting because Trump only recently came out in favor of crypto. He was pretty critical, and he flipped a little bit, which isn't shocking. But we just read that crypto companies are now major or dominant corporate sponsors, political spenders. So I think there's a lot of political pressure, and in these oversight hearings that Jane mentioned, it was a big source of conversation. There's pressure on both sides. I think that there's a need for clear rules and definitions and transparency, and I think that pressure is just building more and more. You do hear Republicans talking about it more than Democrats, but I think the pressure is still there on both sides. And I do think that we will see movement. I'm not sure when, but.
Yeah, and Commissioner Peirce at that same committee hearing basically said, in a very sort of a critical way, she said the SEC uses enforcement as its leading foot in the crypto space, the digital asset space, instead of using regulation with respect to digital assets, which leaves, as she said, people to read the tea leaves on enforcement action. So there's a real push for regulatory clarity, a real framework around digital assets. which I think will then help sort of pave the way and make everybody more comfortable with putting it into a retail product. So, and again, because so much of their regulation has been around enforcement, and so you're kind of always looking at what does this mean, what does this not mean? And she was very critical, and she's been pretty supportive. That's why she's has the moniker Crypto Mom, you know, in terms of her views on crypto. So, but I do think that there's pressure, equal pressure on the Democrats because of the political donors. We're reading 50% are pushing towards probably in both directions. So I don't think you're going to see a hard line that this is never going to happen. I do think we're trending in that direction.
Okay, one more SEC question, and would love your insight. So almost every meeting I go to, people talk about a fund with an ETF class and a mutual fund class. And as we all know, Vanguard, certain index funds, they have exempted relief, and they've offered that structure for, you know, over a decade. It is, you know, my understanding that the Division of Investment Management, and really taking a cue from the chairman's office, is against granting another ETF complex or a series the ability to offer ETF mutual fund kind of dual class products. And even though there's 7 or 8 exemptive applications that have been filed, and I think the staff has struggled with whether one class of shareholders, meaning the ETF class of shareholders, are somewhat disadvantaged as compared to their mutual fund fellow class shareholders. And you mentioned swing pricing, and I also heard that they would not move forward in allowing additional fund complexes to offer such products until they resolve swing pricing. That may be a little dated. I don't know what their current thinking is. Certainly that may change with the new administration, but what is your latest thinking on kind of the dual class ETF mutual fund?
I can start, I guess. I mean, there are over like 30 applications in, so there's a lot of pressure on the SEC to do something. I mean, they're pending. I think, you know, offering ETFs as a share class would likely remove the need for conversions. I mean, so there's definitely some benefits there. I think that, I don't know, I tend to be a little bit more optimistic here. I think we might see some movement next year because there is so much here. We just heard something yesterday that was interesting.
Yeah, I just had a conference yesterday where Natasha Greiner, the head of the Division of Investment Management, addressed this issue and said that with all the applications before them, there are some variations between them. But she said, we're very actively working on it. There's lots of dialogue. We're looking for a solution that's fair to everyone. So, and they're looking big picture. So I think we might not see it application by application, but we might see a more wholesale response. They know that there's a demand for this. I think they're trying to do what they can do. But, you know, Bibb, you and I were at a meeting where people were saying how you submit applications, you got 1 million staff questions. So people are just, you know, paying for the lawyer fees, and then applications go nowhere. And even when the staff doesn't have any more questions, then it just sits. So I think that we will see something. I don't think we're going to see something tomorrow. I think it will take some time. I don't know what form we'll see something, but I think there will be movement. We just have to be patient. And I think, you know, as evidenced by your thumbs up, the lawyers are going to make some money off of it.
So one of the questions is sort of what is the issue? And maybe we just need to step back a second. So basically the ETFs are looking that, as Bibb mentioned, Vanguard is the only player that allows for an ETF share class off of a mutual fund. And they were given this patent years ago. And the patent expired, I think, last year. And so there's a lot of people who want to offer an ETF share class off of a mutual fund. And you can only do this through an exemptive order with the SEC. So you can't just do this on your own. You have to get the SEC's permission. And so the big question here is, will they allow other players to have the same structure as they allowed Vanguard years ago? And so that's why it's become so popular, is because the patent expired and suddenly it's looked at as an option to offer an ETF off of a mutual fund. So that's the big issue. That's one of the big issues for ETFs. I think they're spending a lot of time on this.
But the issues from, I guess, the staff's perspective is they're worried about cross-subsidization.
Right, exactly.
They're worried about operational challenges.
They're worried that the ETF share class will absorb all the costs from the mutual fund share. So it's kind of, although if you look at it another way, the ETF investor can get out, intraday. The mutual fund investor has to get the end of the day pricing. So I think there's costs and benefits for both. And there tends to be this concern from the SEC that one class will benefit over another. And that's where they have the big concerns.
Or will subsidize.
Or subsidize, exactly. So again, have they seen that? Not necessarily. Is there an actual issue here, or is it really academic? I tend to think it's more academic, because is there material harm, or is there more benefits than there are? So I think that's just something that the SEC has to get comfortable with. They haven't so far. All these applications have, tried to address the issue and tried to make the SEC comfortable. Haven't worked yet, but maybe the SEC is working through this.
It's consumer protection.
Yeah. So, and the Bibb is probably closer to this than we are, because I'm sure you're working on some of these, but this is just our understanding.
But I think in the SEC's mind, they will say, well, why do you need this? Just do a conversion. So I think there's skepticism.
Let's switch to the judiciary branch, if you will. And then this is interesting, because we began this talking about how important it is when you have a new administration in. So it's not only just picking the chair, but it's also picking filling vacancies on the Supreme Court and circuit courts. And so we have to go back 2 administrations to the Trump administration and his appointees, and they're having great impact right now. The big case was the Loper Bright Enterprises case that overturned Chevron, which meant that judges no longer had to give deferential treatment to the expertise of the regulator, in this case, the SEC. There have been a couple of ambitious rules by the SEC regulating ESG, both on the corporate side and the fund side, as well as very new rules for hedge funds. Both of those were stayed by the Fifth Circuit. So how's that, maybe Jane, you can start. How is that impacting the SEC rulemaking and otherwise?
Well, I'm just going to talk a little bit about a couple of the cases, because they're kind of interesting. So what you mentioned, the Loper Bright case, which is interesting about this, has nothing to do with the SEC, nothing to do with the financial services industry. It was a group of herring fishermen that sued the National Marine Fisheries Services, which is I think a branch of NOAA, I think. And they basically suing them after the service adopted a rule that required the industry to fund a monitoring program. So, and apparently it was a very large fee, like $700 a day to have a monitor on your ship. And I believe Loper Bright might even be a ship. So it has nothing to do with the SEC, but it's basically the services, this National Marine Fisheries Services said, hey, this is a monitoring we're requiring, and you fishermen are going to pay for it. And they said, no, you're requiring it, you pay for it. So basically the Supreme Court, when they were determining this, decided we're going to overturn the Chevron doctrine, because we agree with the fishermen that, and the Chevron doctrine goes back like 40 years and basically says that that required courts to defer to agencies' reasonable interpretations of otherwise ambiguous statutes. And by overturning this, it's a new holding shift that takes the power away from the agencies and towards the judicial system. So courts must now exercise their independent judgment in assessing the meaning of these statutes rather than sort of deferring to the agencies. Again, the case and opinion did not involve the SEC, but the principles will apply to all federal agency rulemaking. So it's a pretty big case. I think we'll talk about it in a second about its likely impact, I think, in terms of policy making over the years. There's another couple ones I just want to mention really quick. The Supreme Court also has one out. It was called Corner Post, and that had to do with a case that concerns the interchange fees associated with debit card transactions. Again, not SEC, but that also is one that's sort of interesting because it clarified the time within which a party may sue an agency under the APA starts to run when the rule injures the plaintiff and not necessarily connected to the statute 6-year statute of limitations. So in other words, you could be a company, just determine that a rule is hurting you and bring a suit against an agency 10 years after the rule was adopted, and you may not have even been in existence during the rule. So again, I think it's just an example of how they're whacking away at the APA. And one more case I'm just going to mention, and that the Supreme Court came out with was the SEC versus Jarkowski. This basically, the court struck down a statute that authorized the SEC to seek civil penalties under the securities law through their typical in-house proceedings in front of an ALJ court, and instead said the court found that this practice violated the 7th Amendment because it deprived defendants of a jury trial. So I think it's going to make enforcement cases a little bit more difficult because you can't go through that ALJ process as much. Did you want to mention the Fifth Circuit cases that he alluded to?
Yeah, we can talk about the Fifth Circuit, but I think the bottom line is that the SEC is taking a beating, even in cases that don't involve the SEC, right? Yeah. Agency rulemaking and regulation is not what it used to be, right? The deference being paid to agencies like the SEC is not there as much. And so in terms of the impact to us or to you, it's going to be easier to challenge SEC rulemaking. You have more ammunition to do so. There's more pressure on them to, clearly state what the problem is that they're trying to solve. There's more pressure on them to have statutory authority to do what they're doing. These broad rulemakings that are proposals that we've seen under Gensler they seem to throw in everything but the kitchen sink. I think that's gonna swing back a little bit. And there's just more pressure on them to get it right the first time and not throw in 100 alternatives into a proposal and then say, well, we brought it up as an option, so now we'll adopt it. And so I think people won't have to comment as much. There won't be as much pressure on shorter comment periods like there was. And then I agree with Jane that enforcement is going to take a hit. But I think as a result, and an important impact to all of you, is that exams are going to get tougher, right? If they're not going to bring things to enforcement, they're still going to kill you by 1,000 paper cuts and do these exams where a smaller firm that doesn't have the resources to push back is going to be quicker to cave and just say, okay, we'll settle, we'll do what you want, just leave us alone because, the paper has cut us off.
And we could also see, sort of to retract what I just said, we could also see SEC enforcements by basically laying out a regulation. So if they can't get a rule through, they may just do it through enforcement. And that's sort of what they've been doing with the digital assets. And we may see some of that as well. The SEC knows what it wants to see. They feel comfortable in certain areas. And if they can't get a rule, they're going to either get it through examinations or enforcement. So that's
right. If they say, you know, we'll see regulation by enforcement, but we can't see enforcement, so we'll make the exams really tough.
Yeah.
And, you know, we'll pressure you to do what we want through that examination process. So in that Fifth Circuit, the case that you talked about, the private fund ruling, is important because it really questioned the SEC's statutory authority. And so some of the active rulemaking that we see right now, like advisor outsourcing or like cybersecurity or safeguarding, that relies on that same statutory authority, we're seeing being held up, right? That's another reason why I don't think the SEC is doing much or going to be doing much, because, you know, they're getting beat up in the courts and they can't just rely on the same old statutory authority because it's not serving them well. In Fifth Circuit and other circuits as well, I think are, you know, taking note. I think, you know, there are a couple of big cases right now in the hopper that could be telling.
Yeah. So, I mean, just to sort of finish this little discussion up, there's a couple of cases I think that will immediately look to the overturning of the Chevron possibly. There's a DOL case. The DOL adopted a rule intended to permit ERISA benefit plans to consider ESG factors. No surprise, it was challenged. It was held, the Northern District of Texas actually held that the rule was permissible under a reading of ERISA using Chevron. But now that that decision is now on appeal to the Fifth Circuit, so I think that creates one of the earliest possibilities of an appellate court to conduct a post-Chevron analysis. The Eighth Circuit also has been given the, they will be hearing the challenge to the recently adopted SEC rule that requires climate disclosure for issuers, corporate issuers. And again, I think that's another area that where the overturning of the Chevron doctrine could have an impact. So we're going to see things, I think, very quickly. And I do think it's probably going to open up a lot more litigation here. So.
Why don't we rapid fire a couple of questions and then we'll conclude. So the fiduciary rule, it's tortured history. Any predictions as to whether there'll be more torture, more changes?
I mean, yeah, I mean, just really quickly, earlier this year, the DOL adopted, once again, changes to the fiduciary rule to broaden the definition of who is considered an investment advice fiduciary under ERISA and IRS. And they primarily did this in order to capture those one-time rollovers that everyone does, and which were not typically captured by the current definition. So they wanted to make sure that if you are a person coming in to roll over into an IRA, that you actually had an ERISA fiduciary doing that and you weren't put into a product that was not suited for purposes. So there's a lot of good intentions there. The rule would have been effective actually this September. Two cases immediately challenged the rule, one by Federation of Americans for Consumer Choice and another by the American Council of Life Insurers. And two district court judges in the Fifth Circuit, surprise, surprise, separately issued nationwide stay orders, basically because they said the plaintiffs are likely to win on the merits because the rule conflicts with ERISA and suffers from a lot of the same fatal flaws that the 2016 rule suffered from, which, no surprise, was vacated by the Fifth Circuit in 2018. So we're seeing this flip-flop, flip-flop, flip-flop all over the place. But I think what's interesting is we're not anywhere near a conclusion on this. It's a very partisan issue, obviously, because and the DOL actually has just appealed both cases, so they're not giving up. This is a hill they are willing to die. But I do think we're going to, depending on who wins the next election, will probably determine how hard the DOL pushes. for this. So, it just kind of flip flops back and forth. It's just, seems like it's never ending.
Let's, Jane, you work at a large company that offers money market funds, maybe the largest, I'm not sure. And that's the most regulated investment company by far. Is the SEC through with regulating money market funds for the time being?
I hope so. I don't think there's any appetite by the SEC staff or really anyone for a money market fund reform 4.0. I think that the nail is in the coffin on that one. So I think they just did a very big rulemaking in July of 2023. It actually, compliance date was just last week, or actually earlier this week. And I think that's it. So hopefully. So my answer is no.
And so my last question is directed at you, Lisa. A lot of the viewers, I'm sure, are members, or the companies are members of the ICI. Some of them might not be. So the ones that are members, how can they give their views and opinions on some of the issues we've talked about today? And then how can those non-members become members if you want to persuade them to become a member?
Sure. So ICI is run by committees, and all the member companies can serve on the committees, can serve on working groups. And so, we have meetings, we have phone calls, and we service the members. So if members have views, they just need to tell us, and we will advocate on their behalf. Some of the committees are, not everybody from a company can serve on a committee. So if your company is a member, I would recommend that you find out who serves on the committees, and, find out if you can. If not, you're always welcome to call us or shoot us a note, and we can tell you who serves on the committee, or we can, bring your voice to the forefront. If your company is not a member, then you definitely should become a member, and we can help you with that as well. So all you have to do is shoot me a note or call me. I can put you in touch with our membership department, who can tell you all the benefits of membership, and I'm sure you will not be sorry.
Great. So as I began with, there will be a part 2 webinar on these topics and new topics. We haven't set a time because of all the variables we were talking about. So certainly if there's not a new chairman, it may not be time to talk or discuss, but keep an eye out. There will be a part 2. And I want to thank Lisa and Jane very much for participating. I thought it was a great webinar. Thanks to you.
Thank you.
Thank you.
Yeah, thank you very much.